So thank you, Helma, for inviting me and for all the other organizers. It's a great pleasure and honor to be part of this important conference. And thank you all for coming to this talk. My work, as Helma said, focuses on human trafficking and develops a labor approach to human trafficking, one that understands vulnerability to exploitation as resulting from structural causes, rather than only the criminal activity of deviant outliers. One of the sectors I study is care work, and that will be the center of my talk today and, of course, of this conference. So in my talk today, we'll look at temporary migrant care workers, particularly live-in care workers working in the long-term care sector, taking care of the elderly and the disabled, and specifically the impacts of COVID on these frontline workers. But to talk about COVID, I would like to first characterize the routine working conditions and vulnerabilities that characterize the lives of live-in migrant care workers in many countries around the world, because only understanding these underlying conditions can explain their situation under COVID. And so my talk will be made of three parts. Each one is based on a different research project. First, I'll discuss the structural vulnerabilities that characterize the working condition of migrant care workers, particularly live-in ones in temporary migration programs. I'll discuss their situation using the concept of a continuum of vulnerability. Second, I'll discuss the situation under COVID and how these underlying conditions were exacerbated and led to extreme conditions of confinement, isolation, and around-the-clock work. And finally, I will discuss the opportunities and coalitions that COVID specifically, but the care arrangement more generally, may open up. Throughout, I will use the Israeli case as an example. Israel is both the case I know best, it's where I'm from, but also a country with, by now, an experience of 25 years with temporary migrant work program in the care sector, a highly restrictive migration regime, and a very vibrant civil society working with and for promoting workers' rights. While various elements in the Israeli case are particular to Israel, others are characteristic of temporary migrant work programs in Europe and other OECD countries, and we've heard about them in different talks throughout the last 2 days, and we'll hear more about them tomorrow. So a lot of this will sound familiar, even if it focuses on Israel. The talk will also build on research conducted as part of my ERC-funded research group, TrafLab, Labor Perspectives on Human Trafficking, and the Workers' Rights Legal Clinic at Tel Aviv University, at the law school, operating as part of it. We operate as part of the Workers' Rights Clinic, a hotline for employers of migrant workers, in the hope of educating them about decent work and learning through the hotline where common ground between care workers and care recipients may lie. And I'll talk about that at the final part of the talk. So let's begin with the routine day-to-day pre-COVID employment of migrant domestic workers and the concept of a continuum of vulnerability. So part of the liberal understanding of the labor market is based on a dichotomous distinction between two different creatures, between decent, good work, or at least, kind of good work, on the one hand, which is the labor market we know, and an extreme criminalized situation of severe exploitation that amounts to human trafficking. Under this dichotomous understanding, we have these two different phenomena. One is the realm of the labor market, where most workers work, characterized predominantly, again, by decent work, which is based on consent, on choice, and control of working conditions. These work relationships are therefore predominantly regulated using labor and employment law and a lot of contract law. Another totally different creature is that of human trafficking and modern slavery. Here we imagine a totally different situation characterized by force, fraud, and coercion, resulting in workers' unfreedom. The law responds to this situation by criminalization. And when the victims are migrants, by border control mechanisms or border protective mechanisms, and a thin layer of human rights protections. However, to many of us here, working with and researching migrant care work, this dichotomous picture will clearly seem totally misguided. The case of migrant care workers is one strong example that this imagined world of choice, consent, and control that is the labor market isn't really a world apart from the world of unfreedom that characterizes human trafficking. Rather, the difference between them is one of degree. And perhaps it's best to put them on the same continuum. which we can call, following others, a continuum of exploitation, or I prefer to call it a continuum of vulnerability. Under this understanding, the work contract and workers' labor conditions are shaped by wider socioeconomic conditions and legal rules and institutions, such as immigration law. We've heard a lot about it in these 2 days, welfare law, employment law, the structures of employment, the intermediaries that enable this employment. All of these impact workers' bargaining power and may place them in conditions of vulnerability. One's position on this continuum of vulnerability depends on her bargaining power. A worker's ability to have some measure of control and choice in relation to her working condition depends to a large extent not just on market supply and demand dynamics, as economists might tell us, but rather on structural elements that shape her options. According to the continuum approach, most workers enter into a work contract under some form of economic compulsion. In labor sectors where there is a surplus of labor, workers are in a relatively weaker bargaining position and therefore are more vulnerable to exploitation and commodification. However, market supply and demand are themselves a product of policy and are not the only factor determining bargaining power. A worker who's strongly dependent on her job for income, who's dependent on her job for status, may fear losing her livelihood or her status because of losing her job. She will fear leaving even an abusive employer or stirring up trouble at her workplace by complaining or turning to the authorities to lodge a formal complaint, making her more vulnerable to exploitation because she has no remedies available to her. The structural power imbalance between the parties to the labor contract characterizes the work experience of many workers and constitutes the normative justification for welfare states to adopt decommodifying measures in the form of protective employment legislation, prescribing, for example, minimum wage, overtime regulations, safety standards, as well as protections for workers seeking to unionize. So from this perspective, there's a spectrum, of course, this perspective that stems from Marxism. There's a spectrum of forms of economic coercion and commodification. Some level of coercion exists throughout the spectrum, and human trafficking appear on its extreme coercive end. The difference between routine exploitation of workers and trafficking is a matter of degree and not of kind. Some unfreedom and coercion exists throughout the spectrum, a different situation, beginning with mild routine violations of labor law and ending with extreme exploitation at the far end of the continuum. Under this understanding, in order to start addressing the problems with the most exploited workers, we'll have to understand the way the whole continuum develops. Let us now turn to examine where migrant workers in many temporary work programs, and not just in the care sector, are on this continuum, looking at what structures their vulnerability. First, I want to highlight the cultural and identity-based vulnerabilities: ethnicity, race, caste, nationality, gender, vulnerabilities that are caused by the way specific identity traits are interpreted and the meaning they get in the market that enhances worker vulnerability to exploitation. And these may differ from one market to the next, but some have commonalities that we all know. However, these are just part of this story. Workers are not just exploited because they're women or because of their race or nationality. These are exacerbated by structural vulnerabilities. So the illegal status and its implications to one's access to police and to the justice system, fear of deportation, debt incurred in the process of migration that makes the worker more docile and willing to work in terrible working conditions, mobility restrictions such as tight visa arrangements that makes one's visa depend on working for a specific employer, exclusions from labor and employment laws, thus granting workers a different baseline of rights and protections, physical and social isolation through housing requirements, or in the case of care work, some elements that may be related to some extent to the nature of work, individualization, restrictions on family migration, or restrictions on community building and on collective action and organizing, and finally, an allocation of responsibility to those who profit most from the workers' exploitation, or actually no allocation of responsibility. Corporations, intermediaries, lead firms in the care industry, placement and recruitment agencies that bear little responsibility for what happens to the workers. In order to address migrant worker vulnerability to exploitation, we need to rethink each one of these building blocks that create this wall of worker vulnerability. Dealing with one aspect alone might be good, but it will be insufficient because they work in tandem to create a docile, obedient, vulnerable, available, and cheap workforce. So let's now turn to migrant care work using the example of Israel. There are approximately 70,000 migrant care workers in Israel. Approximately 60,000 of them are documented. They arrive mostly from Southeast Asia. A third come from the Philippines, and a lot of them come from Eastern Europe as well, Moldova and Romania. They enter Israel on a visa that allows them to work only in the care of a disabled, the care for a disabled or elderly person, so it's not going to be children, for a period of 5 years, though under some circumstances, not that rare, that depend on the need of the patient, of the care recipient, the visa may be extended. The routine pre-COVID migration and work arrangement renders the workers in a highly precarious situation, even if we look only at documented workers. So I'm not even going to talk about status here. Let's look at the documented workers that are under Israel's migration regime to the care industry. So first, debt. Workers come in incurring large debts of an average of $12,000 US, which means they have to work for several months to pay off their debt. Mobility. The workers are tied to a sector and can move between employers only up to 3 times. However, some of the workers are tied to a single employer. This is the case for workers whose visa got extended, I mentioned them before, or were at the last period of their visa. Of course, being tied to one's employer is a source of immense vulnerability because leaving that employer for any reason entails losing one's legal status. In addition, there's isolation. Workers are required by law to reside with the employer and are not allowed to live elsewhere. This causes the well-known problem of many care workers to separate work and leisure, of many live-in, but not only care workers. So the difficulty to separate work and leisure and to limit their availability to their employers. And it increases employers' control over many aspects of the life of the worker, including not only their sleep and rest, but also food, hygiene, socialization, etc. Another factor is the legal exclusion. The control of employers caused by the housing arrangement is compounded in the Israeli case by the workers' exclusion from overtime pay, making their work around the clock affordable to many care recipients. Their affordability, it should be noted, is also due to a long-term care benefit that covers part of the cost of their wages. It's paid to the employers or to an agency. The workers, therefore, are further subsidized not just by the benefit, but by their exclusion from overtime pay and rest time legislation, make them highly affordable. Individualization. Workers are individualized to their detriment in 2 ways. First, by the prohibition on migrating with family members or forming a family in Israel, and second, by the structure of employment, by many small employment agencies or individual employers that makes unionization, coming together collectively, not just challenging, but basically impracticable due to the small bargaining units. Finally, employment and manpower agencies violate workers' rights with near impunity due to lack of effective enforcement and insufficient publicly available information about the agency, making it difficult for workers as well as care recipients and their families to distinguish between different employment agencies based on their treatment of workers. So this was the situation pre-COVID. Considering all of these structural vulnerabilities, where would you position migrant care workers in Israel on the spectrum of vulnerability? This is even before they met an employer that may end up being exploitative and abusive, or may not be. The structure itself, as I believe, positions them already on the side of intense vulnerability, this part of the continuum. And then came COVID. We already heard Ito Peng's wonderful talk yesterday about the harsh impact COVID had on migrant care workers in many parts of the world. It played out similarly in Israel. So the COVID pandemic reached Israel at the end of February 2020. At the early stages of the pandemic, Israel adopted swift and strict policies to contain the pandemic. A strict lockdown, border closure was introduced a couple of weeks after the first diagnosed COVID patient was detected. 3 lockdowns were introduced in the last year, in March, in September, and in December, each lasting between 4 to 6 weeks with different levels of stringency. Regulations throughout the first year of COVID kept changing rapidly. However, at the height of lockdowns, situations that will probably be similar to you. Businesses deemed non-essential closed. The education system was shut down. Gatherings, indoor and open space were prohibited or restricted. And people were asked basically to stay home. At the height of lockdowns, people could leave their house for designated purposes, work, grocery shopping, exercise, etc., but otherwise were asked to stay within a 500-meter parameter from their homes. At the same time, protective regulation was introduced to protect workers and the public in essential sectors, including requirements for personal protective equipment and social distancing. These measures were accompanied by border closures and a 2-week quarantine requirement to entrance once borders were open. Due to the shutdown of businesses and resulting loss of income and high levels of unemployment, the government introduced wide decommodifying measures to ensure continued income. These included relaxation of some eligibility requirements to unemployment benefits, extension of unemployment benefit eligibility period, a one-time universal cash transfer, and various assistance packages to support small businesses and independent contractors. All this had a distinct implications and modifications in relation to migrant care workers. And 3 building blocks in the wall of migrant care workers' vulnerability were significantly intensified. The contrast between citizen and non-citizen workers was apparent. Non-citizen workers, all of them, not just migrant care workers, were excluded from these decommodifying measures that I just discussed, were not eligible to the benefits and assistance packages, were provided only to citizens and permanent residents working in the formal economy. It should be noted, care workers were essential workers, so they had continued income, but those who were undocumented may have lost their work for various reasons, and they had no assistance from the government. At the same time, they were subject to strict regulations that were particularly severe in their impact, well beyond the restrictions introduced to the general population. So let me focus on the issue of mobility and of isolation. As we all here know, even before COVID, the requirement to live with the employer, the long hours of work, the prohibition on family formation, coupled with the intense, demanding, and intimate nature of care work, leads to workers' isolation and detachment from a migrant community or from any community. To mitigate the isolation and detachment before COVID, many workers shared community apartments that several workers rent together, usually close to city center, that they use during their day off. As they cannot afford the cost of renting a place outside the employer's home individually, and because, as I said, by regulation, they're not allowed to live outside the employer's home, these shared weekend flats, weekend apartments, allowed them community life, social interaction, and rest. Their time in community apartments, therefore, serves not just a great need for physical rest, but also a form of leisure, of human connection, of social and community existence. During the pandemic, migrant care workers, like the rest of the population, were under lockdown and asked to stay at home. Yet care workers' accommodation with their employers meant that they were, in fact, under lockdown within their place of work. Moreover, because the elderly were an at-risk population, many of them did not leave the house at all. And the care recipients did not receive visits from family and others. As a result, many care workers could not even get their day off and leave the workplace at all. Moreover, regulations and instructions by the Ministry of Health and the Immigration Authority prohibited them from using their community apartments. The prohibition was justified as a measure to prevent the spread of COVID. The regulation further clarified that workers could spend time in individual apartments, vacation homes, of course, ignoring the economic infeasibility of such an alternative for most workers who earn minimum wage. As a result, many workers remained for months as sole in-home care providers to disabled and elderly individuals with no ability to exit their workplace. The new regulation further restricted the limited rights migrant care workers had for leisure time and privacy, and significantly increased employer control and surveillance over them. Now employers were empowered by regulation to ask care workers not to leave the house and to inspect what they did and who they met with during their days off, if they had any. Data gathered by civil society organizations indicated that months after the beginning of the pandemic, many workers had no rest and simply stopped leaving the employer's house altogether, some not having even one free day outside the house for months. The inability to leave the place of work when work and home are the same and to socialize with anyone but the employer meant that all aspects of rest, leisure, private and family life were suspended. Workers subject to these conditions were denied the ability to exit their role as workers and to live fully human and multidimensional existence for several months. Such a situation clearly commodifies the workers as key aspect of their humanity other than their labor power or denied. COVID-19 regulation prioritized employers' interests over the workers, intensifying worker commodification and treatment as mere instruments performing labor, not as humans with needs beyond work and subsistence. And we can see here, though that COVID-19 did not so much create these new vulnerabilities, but it clearly intensified existing ones and exposed the controlling and restrictive regime that was already in place. I would like to carefully suggest that perhaps COVID-19 also created some opportunities and created some cracks in the restrictive system of migration of care workers. The impact of the COVID-19 outbreak and the closures and restrictions that followed it were mostly negative, as I've discussed so far. The situation of many non-citizen workers, including migrant care workers, deteriorated and vulnerability to exploitation increased. Nonetheless, COVID-19 policies, by heightening and intensifying the structural vulnerabilities of migrant care workers, have also drawn attention to their humanity, essential role in the Israeli economy, and created some, even if limited, opportunities to re-examine policies and perhaps improve workers' working and living conditions. Through heightened attention to vulnerability, but also through opening up a possibility for new coalitions and solidarities. Now, most of what I'm going to talk about is an option, is a potential. It's nothing that came about yet. But what we did see, first we saw some new appreciation for care workers and the service they provided, both on social media and in traditional media. There was increased attention to their contribution and their plight under COVID. Second, extension of stay in Israel. Perhaps the most striking change for all non-citizen workers, one that Ito Peng discussed yesterday as well, has been the extension of visas of temporary migrant workers. As we saw yesterday in Peng's talk, Israel was not alone in this development. We've seen it in Canada and other EU countries, changes in exclusionary migration regime into a more inclusive one. Perhaps the best example of this is Portugal, that in March 2020, under the emergency measures used to mitigate COVID-19, granted residence to immigrants and asylum seekers who already opened residence applications processes with its immigration and border services. In Israel, no such sweeping move was taken, yet several developments cracked the strict temporary stay requirements. Migrant workers' visas were extended as a result of the pandemic, and undocumented migrant workers were given for the first time permits to work in the care sector in old age homes. While these were all temporary changes, possibly reflecting no more than government responsiveness to the needs of the market and not humane treatment of workers, it still opened up new options, showing that what was perceived as an impossibility due to skill level or fear of settlement is in fact possible. Finally, the pandemic highlighted the intense dependency caused by the one-on-one, around-the-clock care employment structure. It made it evidently clear that this dependency is problematic for both care recipients and care workers, and perhaps, if used by migrant workers groups and civil society actors, can create a path for the formation of a new coalition between care workers and care recipients. I suggest this with a big question mark around it. Yet all these developments need to be considered side by side with the possible negative legacy of COVID. First, COVID policy clearly exposed the instrumental treatment of workers as servants of the need of their employers. Regulation was restructured to serve employers' safety and convenience with little or no attention to workers' humanity and needs. Second, in relation to care work, the pandemic may have another very troubling legacy. The state's ability to require workers to avoid staying in community apartments, de facto leading to their continued stay at the employer's house and under their control with less or no days off and time off, could be an attractive option for some employers who may continue to require this in the future. Now it's possible. It's too early to know the lingering impact of such change, but the slow relaxation of COVID restrictions in relation to migrant care workers and existing patterns of around-the-clock care in the sector may lend themselves to intensification of demands of availability and totality of service from workers. I want to exemplify all of this with some quotes from the employer's hotline operated by the Workers' Rights Legal Clinic at Tel Aviv University. This is a hotline that aims to inform employers of migrant care workers of how to employ them well, abide by the law, and create a decent work environment. Individual employers write an email or post on Facebook their situation and questions regarding the employment of migrant care workers. I can discuss the challenge and reasons for opening up such a hotline under a workers' rights clinic later if you want, but now let's turn to the quotes. Due to the short time I still have, I won't be able to discuss all of them, but let's look at the two first ones here. The instrumental treatment of employers is evident in many questions in the hotline, even of employers who write because they want to be decent employers and abide by the law. So let's take the first long one. My mother employs a foreign worker for the past 6 months. By chance, we learned that she's 8 months pregnant. She didn't tell us. My mother is distressed by this. She didn't like her even before and wanted to replace her. And now, what do? She plans to fly back to the Philippines, leave the baby there, and come back. Do we have to let her return and employ her when she comes back? We see here both the dehumanizing treatment of the worker and the way the structure of one-on-one employment produces this treatment. Similarly, the next quote. A foreign care worker works for us 4 years, 24 hours a day. She's off at 9 p.m. until morning. I want to reduce her pay because she's off work at night. Can I? The current structure of employment makes families presume around-the-clock availability of the worker, so much so that a worker who rests, sleeps at night, socializes, is seen as a reason to deduct her pay. And just to be clear, employers do not pay for work at night. This family member wanted to deduct her regular wage during the day because she has time off at night, okay? And I'm giving these examples, but these are not outliers. This is what we get. This is the kind of questions employers ask us. We got many telling questions during COVID. Here are two characteristic ones. For example, hi, our foreign worker stayed with my mom on Saturdays during COVID. Do I need to pay her for that time? And if so, how much? Here, there is a telling language, right? The possessive treatment. I don't know if it translates well to English. I did the translation, but the idea of our foreign worker, right? How possessive that is. And of course, foreign worker is the translation from Hebrew. That's what the law calls migrant workers. And also the difficulty for the employer to discern work and non-working time. For some of the people, they felt they actually got stuck with the worker on Saturdays, even when they didn't want her there, right? We can also see new challenges posed by quarantine. So that's another quote. My mother employs a foreign worker since October 2019. She wants to fly home for a month in June 2020. If she comes back, do I need to pay her for the required 2-week quarantine? Do I need to pay her to stay in the quarantine hotels? How many vacations days does she have? How much do I need to pay her? We're confused. We found no answers in the directions we received from the agency. So again, you can see here the real uncertainty of employers. Employment agencies are not directing them. The government doesn't provide clear instructions. They just don't know what to do. They don't even know anything about her vacation days, right? This is a question that's not related to COVID. They just don't know. And this is an employer that wants to know, right? This is a good employer that is actually turning to a hotline to ask. I hope these quotes help emphasize and kind of make very real the way the structure of employment before and during COVID dehumanizes the workers, makes their work and life precarious, and leads to a sense of ownership of employers over workers. I do want to try and end, though, with a question that will point to some avenues that can perhaps be more hopeful. So COVID-19 revealed and accentuated some of the shared interests of care workers and care recipients in reforming the current structure of migration and employment. Here are some ways that became evident to us through the questions we received at the employer's hotline. So first, it seems it might be easier now, after COVID, to challenge the one-on-one care arrangement that produced intense dependency and vulnerability on both sides, especially the workers, but also the care recipient. You could see from the questions the heightened sense of dependency COVID created. There are other alternatives that can be considered, though they require deep restructuring of care provisions in Israel. Chief among them is the introduction of live-out arrangements and the option to work in shifts. That is now just not an option. Second, finding replacement for a worker for long employment breaks. Currently, when a worker leaves leaves their employer for a period of time, the Israeli system makes it very difficult to find a replacement. And this is one of the great causes of distress for both workers and employers. And it makes this really, really a difficult moment in the employment relationship. A solution is required, and for vacations, for sick leave, for maternity leave, and currently there's basically none. And these are both interests that are both the employers and the workers. Both are suffering from this structure, and this may be a cause for a coalition. The final four here on the slide are perhaps too deep in the particularities of the Israeli system, but let me just mention them briefly without much explanation in case they pique your interest. So simplification of wage calculation. Currently, it's a mix of welfare, long-term care benefit, complemented by wages from the family or the care recipient, and it's very difficult to calculate how much the family needs to pay. If it was simplified, it would be easier for the worker to know what they deserve and easier for the family to actually follow it. Adaptation and increase of long-term care benefit and employment options, and kind of a more flexible employment options for more complicated care recipients that are currently undesirable for workers. And this again is a great concern of the lobby of care recipients. What to do with these workers these care recipients that no worker wants to work with. The result is all sorts of restrictions for workers instead of thinking of something that can serve both sides. Of course, establish a helpline for migrant workers and a separate one for their employers, right? The kind of service the clinic provides should really be provided by the government. A place to clarify employer obligations and workers' rights and possibly initiate some form of enforcement. And then enforcement against rights violating and misleading employment agencies. Right? All of these are interests of workers and care recipients, two groups that are currently pitted against each other in what is understood as a zero-sum game. One's group loss is the other's victory. But I want to argue that the intensification of the care relationship under COVID, during COVID, made it evident that this is not the case. I believe these examples, or I want to believe these examples, can be the basis for a coalition of change that will improve care workers' working conditions and care recipients' care. Currently, no such coalition exists. I need to be clear about this. The sides are very much in great animosity. But I do hope that we can find a way and be able to be part of this, of its initiation in the future. This is part of the reason we opened the employers' hotline at the clinic in the first place. So I would love to hear from you during the Q&A if you're a part or know of such an effective care worker and care recipient coalition that we can learn from. So to sum up, in this talk, I sought to show the ways in which COVID-19 restrictions meshed into existing policies applied to migrant care workers in Israel and exacerbated them. The building blocks of vulnerability that we discussed demonstrated that employers' control and workers' dependencies are shaped to a large part by government policies and restrictions. And intervention is often required by the government to address the vulnerability created by the same government charged with preventing worker exploitation. Subjecting workers to the employer's control day and night, willfully neglecting their health and safety, severely restricting their mobility, were policies readily available when the pandemic hit because they were in fact in place well before the spread of COVID. However, the same way that existing harsh policies enabled draconian measures in time of emergency, changes introduced during the crisis may inform the imagination in the future, demonstrating that interests served by labor migration can be promoted while maintaining workers' dignity. I tried to sketch and to stock the positive and negative alternatives opened up by the pandemic and to highlight some of the positive openings that were created, as well as the troubling ones. Policymakers, state officials, civil society, workers, and their organizations will be the ones who create COVID's legacy and who will be able to choose which possibilities to pursue. Thank you very much. I'll end here and I look forward to your questions. Thank you.